The defendant, Riverbrooke Solicitors Ltd, had represented the claimant, Ms Sylvia Olukoya, in an employment tribunal claim against her former employer. However, when the legal costs exceeded the original estimate, the claimant expressed dissatisfaction and terminated the defendant's retainer in 2018. This led to the claimant filing a complaint with the Legal Ombudsman. In response, an informal resolution was reached in February 2020, which limited the defendant's total claim for fees to £10,000 plus VAT and disbursements. Despite this agreement, in December 2022, nearly 3 years later, the defendant issued a revised final invoice to the claimant, claiming an additional outstanding balance of £144,951. The claimant applied for assessment of the revised final invoice, and a hearing of preliminary issues took place before Costs Judge Leonard in July 2023. The claimant argued that the informal resolution was a legally binding contract. The February 2020 invoice was a final statute bill, and the defendant was stopped from revising it. The defendant, on the other hand, contended that the informal resolution was not binding. The February 2020 invoice was not final, and they were not stopped from issuing a revised final invoice. Following submissions, the court found the informal resolution to be a legally binding contract, limiting the defendant's costs claim to £13,000. The February 2020 invoice was deemed a final statute bill, and the court ruled it would be contrary to public policy to allow the defendant to revise it. For a detailed summary of this decision, visit tmclegal.co.uk.